If you have been scrolling through social media lately and seeing posts about H-1B visas being denied at higher rates, stricter scrutiny at the border, or rumors that your visa could be revoked without warning, I want you to take a deep breath right now. I know how unsettling it feels when your entire life, your career, your family's future, all seem to hang in the balance because of headlines you cannot fully understand or verify. You are not alone in feeling this way, and that is exactly why I am here today. My name is James, and this is Immigration News Today, your trusted source for fact-based immigration updates without the rumors, without the exaggeration, and without the panic. On this channel, we focus on what is actually happening, what the official sources are saying, and what you realistically need to know to protect yourself and your loved ones. So if you are an H-1B holder, if you are waiting for your petition to be approved, or if you are simply trying to understand what stricter H-1B rules actually mean in practice, this video is for you. Let us start by addressing the elephant in the room. Yes, there have been changes to how H-1B petitions are being reviewed and adjudicated. Yes, USCIS has issued guidance that emphasizes stricter standards in certain areas. And yes, some people are experiencing longer processing times, more requests for evidence, and in some cases, denials that they did not expect. These are real observations, and I am not here to dismiss your concerns or tell you that everything is perfectly fine. However, and this is important, what I am going to do in this video is separate verified facts from the speculation that is spreading online. Because the truth is that while there are legitimate changes worth understanding, much of what you see on social media is either outdated, exaggerated, or taken completely out of context. And making major life decisions based on inaccurate information can be far more damaging than the actual policy changes themselves. So let us break this down together, step by step. First, let us talk about what the H-1B visa actually is and how the process works, because I never assume that everyone watching already knows the full system. The H-1B is a non-immigrant visa category that allows U.S. employers to temporarily employ foreign workers in specialty occupations. A specialty occupation generally requires at least a bachelor's degree or its equivalent in a specific field related to the job. Common examples include software engineers, data scientists, accountants, architects, and medical professionals, among many others. The key word here is employer-sponsored. You cannot simply apply for an H-1B visa on your own. An employer must file a petition on your behalf with USCIS, and that employer must demonstrate that the position qualifies as a specialty occupation and that they are offering the required wage for that position in that geographic location. Now, the H-1B program has an annual cap, which currently limits the number of new H-1B visas issued each fiscal year to 65,000, with an additional 20,000 reserved for individuals who hold a master's degree or higher from a U.S. institution. Because demand far exceeds supply, USCIS conducts a lottery each year to determine which petitions will be selected for processing. If your petition is not selected in the lottery, it is not reviewed at all for that fiscal year. This lottery system and the overall H-1B process have been in place for many years. What has changed more recently is how USCIS adjudicates the petitions that do get selected and how strictly they interpret the requirements for approval. Let me explain what stricter adjudication actually means in practice. When USCIS reviews an H-1B petition, the adjudicating officer is looking at several factors. They want to verify that the job being offered truly qualifies as a specialty occupation. They want to confirm that the beneficiary, meaning the foreign worker, has the required qualifications for that specialty occupation. They want to ensure that the employer-employee relationship is legitimate and that the offered wage meets the prevailing wage requirements. In recent years, USCIS has placed increased emphasis on certain aspects of this review process. One area that has received more scrutiny is the specialty occupation requirement itself. Officers have been trained to look more closely at whether the job description matches what would typically require a bachelor's degree in a specific field. If the job duties seem too general or could be performed by someone without a specialized degree, the petition may face additional questions or even denial. Another area of increased scrutiny involves third-party worksites. Many H-1B workers are employed by staffing companies or consulting firms and are placed at client locations to perform their work. USCIS has historically expressed concerns about these arrangements, questioning whether the petitioning employer maintains sufficient control over the employee's work and whether the specialty occupation requirement is truly met at the end client worksite. Additionally, there has been greater attention paid to the employer-employee relationship itself. USCIS wants to see clear evidence that the petitioning employer has the right to control when, where, and how the H-1B worker performs their job. This becomes more complicated in consulting arrangements or when a worker is stationed at a client site for extended periods. Now, here is where I need to address some of the misinformation circulating online. Some posts claim that USCIS is now denying H-1B petitions at unprecedented rates or that nearly all petitions are being rejected. This is simply not accurate. While denial rates did increase in certain years compared to historical averages, they have also fluctuated based on policy guidance, court decisions, and administrative changes. More importantly, many petitions that receive a request for evidence are ultimately approved after the employer submits additional documentation. A request for evidence, often called an RFE, is not a denial. I want to be very clear about this because I see so much confusion on this point. An RFE is simply USCIS asking for more information before making a final decision. It is an opportunity for the employer and the beneficiary to provide additional evidence supporting the petition. Many RFEs are successfully overcome, and the petition is approved. Receiving an RFE can be stressful, but it does not mean your case is doomed. Another rumor I have seen repeatedly is that H-1B holders can have their status revoked at any moment without warning. This is misleading. While it is true that maintaining H-1B status requires ongoing compliance with the terms of your visa, including working for your sponsoring employer in the position described in your petition, USCIS does not randomly revoke status without cause. If there is a concern about fraud or misrepresentation, there are processes that must be followed. You have rights, and due process protections exist. Similarly, some people believe that leaving your job or being laid off means immediate deportation. This is not how it works. If your H-1B employment ends, you do have a grace period. Current regulations provide up to 60 days, or until the end of your authorized validity period, whichever is shorter, to find new employment, change status, or make arrangements to depart the United States. This grace period exists specifically to provide some flexibility during transitions. Let me now talk about who is actually affected by stricter H-1B rules and who may not need to worry as much as they think. If you are currently employed on a valid H-1B visa with a reputable employer who filed a proper petition, and you are working in the position described in that petition at the salary that was approved, you are likely in a stable situation. Stricter adjudication primarily affects new petitions and extensions, where USCIS has questions about the documentation or the nature of the job. If you work for a large, well-established company with a strong immigration legal team, your employer likely knows how to prepare thorough petition packages that anticipate the types of questions USCIS might ask. These petitions tend to have higher approval rates because they are well documented from the start. If you work for a smaller company or a staffing agency, you may face more scrutiny, but this does not mean approval is impossible. It means your employer needs to be especially careful in documenting the specialty occupation requirement, the employer-employee relationship, and the specific job duties you will perform. If you are currently in the H-1B lottery waiting to see if your petition is selected, the stricter adjudication standards will apply if your petition moves forward. This means your employer should work with an experienced immigration attorney to ensure the petition is as strong as possible from the beginning. If you hold a different visa status entirely, such as an F1 with OPT, an L1 visa, or an O1 visa, the specific H-1B adjudication changes I am discussing today do not directly apply to you. However, the overall trend of increased scrutiny in immigration enforcement is something everyone should be aware of. Now let us talk about what you should realistically do in response to these developments. First and foremost, stay informed through official sources. USCIS publishes policy guidance, policy manuals, and news updates on their official website. If you hear about a new rule or policy change, go to the source and read it yourself. Do not rely on social media posts or YouTube comments for legal information. I am providing educational content here, but I am not your attorney, and this video is not legal advice. Second, if you are currently on an H-1B or applying for one, make sure your employer is working with qualified immigration counsel. An experienced immigration attorney can review your specific situation, ensure your petition is properly documented, and respond effectively to any requests for evidence. This is especially important if you work in a consulting role, if your job duties have changed, or if there is anything unusual about your employment arrangement. Third, maintain your own records. Keep copies of your approved petitions, your I-94 records, your pay stubs, your employment verification letters, and any correspondence with USCIS. If you ever need to prove your status or respond to an inquiry, having organized documentation is invaluable. Fourth, do not make major decisions based on fear alone. I understand the anxiety that comes with uncertainty, but uprooting your life, quitting your job, or leaving the country based on social media rumors is not a sound strategy. If you have specific concerns about your individual situation, consult with an immigration attorney who can give you personalized guidance. Fifth, if you are an employer sponsoring H-1B workers, take the current environment seriously. Ensure that your job descriptions accurately reflect the specialty nature of the position. Document the educational requirements and how they relate to the job duties. If you use a staffing model with third-party placements, work closely with legal counsel to ensure your petitions clearly establish the employer-employee relationship and the specialty occupation requirement at each worksite. Let me take a moment to address the emotional toll that immigration uncertainty can take. I know that many of you watching are not just dealing with paperwork and legal processes. You are dealing with real life. You may have children in school here. You may have a mortgage or a lease. You may have aging parents abroad whom you cannot easily visit because of travel concerns. You may have built a career, a community, and a life in this country, and the thought of losing it all because of policy changes feels overwhelming. I want you to know that these feelings are valid. Immigration is not just about forms and filing fees. It is about human beings trying to build lives and provide for their families. And while I cannot promise you that everything will work out perfectly, I can tell you that the system, for all its flaws, does have processes and protections built into it. Immigration rules typically do not change overnight without warning. Major policy shifts usually require formal rulemaking, public comment periods, and in many cases, litigation that can delay or block implementation. Even when new guidance is issued, there are often transition periods and grandfather clauses that protect people already in the system. Courts have repeatedly intervened when agencies have overstepped or failed to follow proper procedures. This is part of the checks and balances in the American legal system. It does not mean everything is perfect, but it does mean that you are not completely without recourse if something goes wrong. Due process protections exist. If your petition is denied, you typically have options to appeal or to file a motion to reopen or reconsider. If you face removal proceedings, you have the right to appear before an immigration judge and present your case. The process can be slow and frustrating, but it is not arbitrary. Now, I also want to touch briefly on something I see a lot of confusion about, which is the difference between USCIS processing and what happens at the border or at a consulate. USCIS handles petitions filed within the United States, including H-1B petitions for workers already in the country who are changing or extending their status. If your H-1B petition is approved by USCIS and you remain in the United States, you can begin working for your new employer or continue in your current role based on that approval. However, if you travel abroad and need to return to the United States, you will need to present yourself at a port of entry and be admitted by Customs and Border Protection, also known as CBP. Additionally, if your visa stamp has expired, you will need to apply for a new visa at a U.S. consulate or embassy abroad before returning. The consular officer at the embassy is making their own determination about whether to issue you a visa. They may ask questions about your employment, your qualifications, and your intentions. This is a separate process from the USCIS petition approval. An approved petition does not guarantee that the consulate will issue a visa, although in most cases, if your petition is valid and your documents are in order, you should be fine. At the border, CBP officers have broad authority to question travelers and determine admissibility. They can ask about your employment, your travel history, and your purpose for entering the country. They can also inspect your electronic devices in certain circumstances. This is not new, but some travelers report increased scrutiny in recent years. My advice is to always travel with copies of your key documents, including your approval notice, your employment verification letter, and evidence of your ongoing job. Be polite, answer questions honestly, and do not volunteer unnecessary information. If you have concerns about an upcoming trip, consult with your immigration attorney beforehand. Let me also mention something about the H-1B registration and lottery process that has caused confusion. USCIS has implemented an electronic registration system for the H-1B cap, which means employers must first submit a simple registration for each prospective beneficiary before the lottery. Only if the registration is selected does the employer then file the full petition. There have been concerns about fraud in this registration process, including reports of individuals being registered multiple times by different employers to increase their chances of selection. USCIS has taken steps to address this, including implementing a beneficiary-centric selection process where the lottery is based on unique beneficiaries rather than the number of registrations submitted. This change was designed to level the playing field and reduce fraudulent multiple registrations. If you were registered through a legitimate employer for a legitimate job opportunity, this change should actually benefit you by reducing the unfair advantage that fraudulent registrations previously created. As we near the end of this video, I want to summarize the key takeaways for you. Yes, there are stricter standards being applied to H-1B adjudications. This is a real development, not a rumor. However, the specifics of how this affects you depend heavily on your individual circumstances, including your employer, your job duties, your qualifications, and how well your petition is documented. Receiving a request for evidence is not the same as a denial. Many RFEs are overcome successfully with proper documentation. Your H-1B status cannot be randomly revoked without cause or due process. There are procedures that must be followed. If your employment ends, you have a grace period to find new sponsorship, change status, or make arrangements. You are not immediately deportable. Large, well-documented employers with experienced immigration counsel tend to have higher success rates, but smaller companies can also succeed with proper preparation. Stay informed through official sources like USCIS, the Department of Labor, and the State Department. Do not make life-altering decisions based on social media posts. Consult with a qualified immigration attorney if you have specific concerns about your situation. General information from videos like this cannot replace personalized legal advice. And finally, remember that immigration processes have built-in protections and typically do not change without notice. The system can be stressful and imperfect, but it is not arbitrary. I hope this video has helped clarify what is actually happening with H-1B adjudications and has given you some peace of mind. My goal with every video on immigration news today is to cut through the noise and give you clear, factual information that you can actually use. If you found this video helpful, I would really appreciate it if you would subscribe to the channel and turn on notifications so you do not miss future updates. Immigration news moves quickly, and I want to make sure you have accurate information as soon as developments happen. Please share this video with anyone you know who might be worried about H-1B issues, a friend, a colleague, a family member. Sometimes just having clear information can make a huge difference in reducing anxiety. And if you have questions about topics you would like me to cover in future videos, leave them in the comments below. I read through the comments regularly and use your questions to guide the content I create. Thank you so much for watching. Take care of yourselves, stay informed through official sources, and I will see you in the next video.